Hello and welcome to Talking Hazards. I'm your host, Colin Pillai, and I thank you for joining me. Today we will be talking about the landmark case of the District of Columbia versus Heller. This court case challenged the Second Amendment and its interpretation as it applies to today's America. So first, let's get some background. In the 1970s, the District of Columbia imposed a very strict law on firearms in the nation's capitals. These restrictions were such that all firearms must be registered in order to be owned. However, handguns could not be registered unless a special license was issued by the chief of police to the person who was trying to register it. Any firearm owned in the home must be disassembled, unloaded, and bound by a trigger lock, which effectively made all firearms useless. Finally, even if you had a special license to own the handgun, you could not possess a firearm on your person at any point in time. So, Dick Anthony Heller was a DC Special Police officer who was authorized to carry a handgun while he was on duty, but he could not take the firearm home at all. He was the only person to ever apply for the license that was part of this court case, which will be important later. Full well knowing that it would be rejected, he still applied for the court case, and the penultimate question was asked. Do the laws of the District of Columbia, requiring a license to own a handgun, having it disassembled and unloaded, violate the Second Amendment? The Second Amendment of the Constitution of the United States, for those of you who don't know, is, quote, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed, end quote. So, I'm going to play a short clip by Munitions Law Group, Cheshire Du Bois, PC, and this will describe the events of the court case and that led up to it and the eventual decision.
So the Heller case began in the Federal District Court in the District of Columbia. This is where generally the lowest federal court where cases begin. In 2003, as I said, all 6 plaintiffs brought suit against the government alleging that the District of Columbia's law was an unconstitutional violation of their Second Amendment rights. Unfortunately, the court dismissed the complaint, said that there was no constitutional violation. Heller and the other plaintiffs appealed to the D.C. Circuit Court of Appeals. This is one of the major United States Circuit Courts of Appeals that you hear about. You'll hear sometimes about the Ninth Circuit, the Sixth Circuit. The D.C. Circuit Court of Appeals is one of those circuits. Heller actually prevailed at the D.C. Circuit Court of Appeals. The Court of Appeals ruled on 2 issues in that case. One, they ruled that Heller had standing to appeal. As we mentioned earlier, Heller was the only plaintiff listed who actually applied for a handgun registration. And because he was the only plaintiff to do that, he was the only one who had standing, which means he was the only one who the court said was actually injured. So all the other plaintiffs were dismissed from the case, and Heller remained. That's why we all know the case as Heller. So after Heller prevailed, the government was not happy. They asked the D.C. Court of Appeals for what is called an en banc review. An en banc review is when the entire appellate court of appeals hears the case instead of just a 3-judge panel. This has actually been in the news a little bit recently. Obama's Supreme Court nominee, Merrick Garland, was on the D.C. Court of Appeals at this time. He did not hear the initial case, but on the request for an en banc review, he wanted to review the case. Ultimately, the D.C. Court of Appeals voted to not hear the case. Therefore, the decision of the court that Heller wins was upheld. At that point, the government asked the United States Supreme Court to hear the case. So after the oral argument in 2008, the Supreme Court issued their opinion. It was a very narrow case, the most narrow case that you can have. It was a 5-4 decision. It was authored by Justice Scalia. It's a beautifully written opinion. Dick Heller prevailed in essentially every way. The court for the first time held that the Second Amendment provided an individual right to own firearms, and importantly, it was right outside of the military context.
So the court case ended in a 5-4 split that the restrictions placed by the District of Columbia on firearms violate the Second Amendment and are thereby unconstitutional. The majority interpreted the Second Amendment as, quote, the term militia should not be confined to those serving in the military, because at the time the term referred to all able-bodied men who were capable of being called to such service. This quote is from Anthony Scalia, end quote. In this case, the government of the District of Columbia is being limited by not being able to enforce such harsh gun laws. Limited government means that the government has a limited amount of power over its citizens and the laws it can impose. Because these laws were deemed unconstitutional, it set a precedent for harsh conditions similar to it so that they cannot be enforced through the rest of the country. I'm now going to play an interview of Anthony Scalia by Fox News detailing the events of the court case.
Gun control. You wrote in 2008 the opinion in District of Columbia v. Heller, the majority opinion that said the Second Amendment means what it says. People have a right to bear arms. Question: how far does that constitutional right go? Can a legislature ban semi-automatic weapons, or can it ban magazines that carry 100 rounds without violating an individual's constitutional right to bear arms?
What the opinion in Heller said is that it will have to be decided in future cases what limitations upon the right to keep and bear arms are permissible. Some undoubtedly are, because there were some that were acknowledged at the time. For example, there was a tort called affrighting, which if you carried around a really horrible weapon just to scare people, like a head axe or something, that was, I believe, a misdemeanor. So, yes, there are some limitations that can be imposed. What they are will depend on what the society understood were reasonable limitations at the time. There were certain location limitations. What
about these technological limitations? Obviously, we're not now talking about a handgun or a musket. We're talking about a weapon that can fire 100 shots in a minute.
We'll see. I mean, obviously, the amendment does not apply to arms that cannot be hand carried. It's to keep and bear, so it doesn't apply to cannons. But I suppose there are handheld rocket launchers that can bring down airplanes that will have to be it'll have to be decided.
How do you decide that if you're a textualist?
Very carefully. My starting point and probably my ending point will be what limitations are within the understood limitations that the society had at the time. They had some limitations on the nature of arms that could be borne. So we'll see what those limitations are as applied to modern weapons.